Today we're going to talk about attorney fees and estate planning. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for the Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to hit that like and subscribe button. It really helps support the channel. Also, a couple caveats before we get going. Today's video is going to be about Minnesota law. Primarily. So if you live in another jurisdiction, talk to your attorneys in that jurisdiction to find out what the ins and outs are. And secondly, today's video is just for educational purposes only. It is not legal advice. Okay, attorney fees. In estate planning, it's going to fall under one of three categories. It's going to fall under, you're going to be billed hourly, you're going to be billed on a flat fee basis, or you're going to be billed on a hybrid basis. So let's start with hourly. Very simply, you're billed at an hourly rate, which is based on the experience and knowledge of the attorney and sometimes the difficulty of the situation. It's going to be anywhere between $100 and $1,000 per hour, somewhere probably in between in Minnesota. Most attorneys bill in increments of 1/6 of an hour, which is every 6-minute increment of their life. So just be aware, that's how you're going to get billed. The benefits on being billed on an hourly basis is you get what you pay for. If you have a very complicated case, it's going to take longer. If you have a very simple case that takes the attorney 15 minutes, you're only going to be billed for 0.3 hours, which would be 18 minutes. Just be aware that if you have a situation that you think is really simple, it might actually be very complicated, requiring additional research or work by the attorney. I have a lot of clients that come to me saying, I have a simple will, I'll put that in air quotes, and it turns out to be a very complicated situation based on their circumstances or based on a challenging distribution schedule that they want to put together, and it will take them a lot longer. Just so you know, in an hourly situation, you will probably have to pay a retainer of a couple $1,000. If the amount billed on an hourly basis is less than the retainer amount, let's say your retainer is $2,000, you're billed at $200 an hour, and it only takes 9 hours, you're going to get back an extra $200 or whatever's left. If the amount that is billed is greater than the retainer, you will owe something in the end. So just be aware, just because you pay a retainer doesn't mean you've automatically paid all the expenses of the situation. The second way you might be billed, and this is becoming more common in the industry, is being billed on a flat fee basis. And it's essentially one fee for service, no matter what the time or difficulty of the matter. Now there are several types, well, really two different types of how these are done. One is a pure flat fee. That will be, say, a flat fee for a will be $10,000. And if it takes the attorney 15 minutes, they're going to win out. If it takes the attorney a whole bunch of hours to do the will, the client will win out. Granted, a will for $10,000, you probably should be looking for another attorney at that point. I don't care what jurisdiction you're in. The second way flat fees will look is more of a staggered flat fee. This will be if it's instead of just saying a will is $10,000, they'll say, let's bring it down. Let's say a will is $1,000, and but if you have a will with a testamentary trust, it's going to be $1,500. This is basically breaking a will and the different services in there into different products and billing for that amount. Some attorneys take this to the extreme. They do the full intake, they figure out what you're going to do, they calculate how many hours they believe it will take them, and then they just give you a flat fee. And that's going to be different for every single client, and that's fine. It's going to probably be fair for the attorney and fair for you, or at least close to that, depending on how many hours it takes. In both situations, you will generally pay in advance. Some attorneys will allow you to pay part in advance and part when the documents or the first drafts are delivered, or part when the final product is delivered. But either way, you will probably be paying something in advance. The final way of billing for estate planning is a hybrid between the hourly and the fixed fee. And this you don't see quite as often, but let me give you an example. Say, for instance, I am doing a codicil to a will. Now, A codicil to will is just an amendment to the will, and it could vary dramatically from I'm amending the majority of the will to I'm amending just a small part of the will. I might say, let's say my rate, it's not, but my rate for a will is $1,000 for a will. I will say I will bill you on an hourly basis, but I will not bill more than $1,000. What I'm doing is I'm putting a ceiling on the amount. So I'll go along and I'll be doing the codicil, and if I'm, let's say, billing at $300 an hour and it takes me 2 hours, you'll be billed $600. But if I'm going along and I'm doing my the will and it takes me 4 hours, instead of billing you $1,200, I'll just be billing you $1,000. The reverse of this is possible as well. It's less common, but it would be putting a floor on it. So the attorney says, I will bill you at least $500 for this codicil, but if it takes me longer than that, I'm going to bill you on an hourly basis. But if it takes me longer than that, I will bill you more. So you're at least going to get billed $500 an hour or whatever the amount is, and then plus anything above that amount. So if they're billing at $250 an hour and they bill 3 hours, the first 2 hours are covered under the $500, and then the next $250 is covered, or you're going to get billed for. The final hybrid, attorneys don't necessarily go this far. I've gone this far in certain situations, but it gets confusing. So what you can do is you can put a floor and a ceiling on it. You can say, I'm going to bill you at least $500 an hour, but no more than $1,000 an hour. We're going to do it on an hourly basis. If it's really quick and easy, I went out. If it's really complicated, you went out. If it's somewhere in the middle, we both went out in the end. So that's pretty much it. That's basically how people bill, or attorneys bill, for estate planning. It's different for probate. That will be the next video. I hope you liked today's video. If you did like today's video, please feel free to smash that like and subscribe button. It really helps support the channel, especially the subscribers. I need to get to 100 subscribers for certain algorithms to kick in, so do subscribe. I would appreciate it. If you like today's video, we do a new video every other Wednesday on various topics between estate planning and probate, so stay tuned in. If you have any questions, leave them in the comments below, or just send me an email. My email will pop up at the end of the video. And otherwise, until next time, this is Gregory Singleton with Signature Law.